Hi all my standard 10 students for the ICSE. Here's your history facilitator Himangi back with you again, and we continue with the judiciary from where we had left off in my previous module. Okay, in the previous module I remember doing with you the independence of the judiciary from the control of the executive and the legislature, and the last point we saw was about the live streaming of the court proceedings. That is the last point that we saw. Okay, now today we are going to continue with the jurisdiction and powers of the Supreme Court. Now I want to tell you one thing, that reading the textbook is very important, and also looking at the pictures. By now your teachers must have told you that seeing the pictures which are given in your textbook are very important, because you have a question which is based on a picture. They can give you any picture from the textbook and you can be asked questions from that. Okay, so please look up your textbook and read your pictures well, so that you know what to answer. You get a whole question on that. Okay, so we come to the jurisdiction and powers of the Supreme Court. I have made a synopsis for you. If you would like to take it, you can stop the video and pause the video and take a screenshot. Okay, now this is your synopsis. You can just keep it with you. Not that I'm going to start referring to only the synopsis, because that is too given in a very short way. We'll start with the textbook. Okay, so please open to jurisdiction and powers of the Supreme Court. Jurisdiction is the power of the court of law that the court of law exercises to carry out jurisdictions and enforce particular laws. The Supreme Court is a protector and the final interpreter of the Constitution. It has both original and appellate jurisdiction as well as an advisory jurisdiction. So first we come to the origin. So what are the different types of jurisdiction that the Supreme Court has? The first one is the original. It's given to you in your notes. See, first one is original jurisdiction, then appellate, then advisory, then revisory, and then we have the judicial review. These are the different jurisdictions of the Supreme Court. We come to the first one, which is the original jurisdiction. Refer to the notes. Original jurisdiction, there are, the first one is any dispute between the center and the state and all interstate disputes, which is exclusive only for the Supreme Court. Then we have a protection of the fundamental rights, transfer to itself a case from the lower court, and interpretation of the Constitution. Now what do we mean by that? It's given in detail in your book. Even in my notes I have written very clearly, details are to be learned from the textbook. So we come to the original jurisdiction. Original jurisdiction means the power of the Supreme Court to hear and determine a dispute in the first instance. That is, in those cases which cannot be moved in any court other than the Supreme Court, they come under the original jurisdiction. And that means a case which you cannot approach any other court. Even the High Court cannot be approached, but you have a grievance, and then you have to approach only the Supreme Court to solve your grievance. Now what are these cases? First one is the center and state disputes between center and state, or interstate disputes. That has been given to you in your textbook. The Supreme Court has been given the exclusive original jurisdiction in any dispute which is between the Government of India and the state, any state. So Government of India and any state, if there is a dispute between these two, then the Supreme Court will rule supreme. Similarly, if there is a dispute between two states, then also the Supreme Court will rule supreme. And then if there is a dispute between, supposing on one side you have the government, means the union government, and one state, these two are on one side and there is another state on the other side, even then you can move the original jurisdiction of the Supreme Court. Okay, so let's read it. Between the Government of India and one or more states, or between the Government of India and any one state, or the states on one side and one or more state on the other side. So it is again government plus state and states on the other side. Between two or more states. So if the government of India is not involved but only two states are involved, even then the Supreme Court has the original jurisdiction. You cannot go to any high court for that. And what are the exceptions to this rule? This is the rule. What are the exceptions to this rule? That this jurisdiction shall not extend to, you must learn the exceptions. It will not extend to any dispute which arises out of a treaty or an agreement which is in operation. That means if a treaty or an agreement is valid, it is in force at a particular moment, then you cannot go to the Supreme Court for any dispute which is arising out of such an agreement. In certain matters, such as the interstate water disputes, the matters referred to the Finance Commission. So if there is an interstate water dispute, or if any dispute has been referred to the Finance Commission, then also the Supreme Court will not interfere. Then there is an adjustment of certain expenses and pensions between the union and the states. So if they are trying to adjust somebody's pension or something, then also the Supreme Court will not interfere, and it has no original jurisdiction. Then the second jurisdiction of the Supreme Court is its protection of the fundamental rights. All these are under the original jurisdictions. So in that I want you all to underline this sentence. Come to the third line. The court can issue several writs for the enforcement of fundamental rights. You just have to remember that, and then you can say any individual can approach the Supreme Court in case of a violation of a fundamental right. We have done earlier in my previous module, I have done with you the various types of fundamental rights which are also given in your book. I had asked you all to learn it before you come for the second lecture, because for the continuing lecture, so that you know what we are talking about. Then we come to transfer of cases from the lower courts. Underline this. The Supreme Court may transfer to itself cases from one or more high courts if these involve questions of law or the cases are of great importance. In such a case, then the Supreme Court can transfer the case from the High Court to itself and make it into an original jurisdiction. Then interpretation of Constitution. All the cases where interpretation of the Constitution is required can be directly filed in the Supreme Court. The Supreme Court has the power of exclusive jurisdiction in regard to questions as the constitutional validity of a central law. So only the Supreme Court can interpret the Constitution in a proper way, because we have people who are expert at this knowledge. We have people who have learned and who are experts. It's not just a layman who is interpreting. So the constitutional validity is something which ultimately the Supreme Court interprets, and that interpretation is final and binding on everybody. Okay, now we come to the appellate jurisdiction. Appellate jurisdiction means, supposing you have a grievance against any court. If a court has passed a particular order and you have a grievance against this order, you are not happy with that order, what will you do? You will go to the Supreme Court and say, I am not happy with this order. Now in such a case, what happens? Either there are two things that can happen. Either the High Court or the court which has the High Court which has passed the judgment with which you are not happy, you seek leave from the High Court that please give us leave to apply to the Supreme Court, and normally the High Court issues a certificate that leave is granted for an application of an appeal to the Supreme Court. But in certain cases the High Court may not even grant you that leave. Then what will happen? Then also you have a right to go to the Supreme Court. How? We'll see it over here in its appellate jurisdiction. Did you understand what I'm trying to say? There are two cases. You can either take permission from the High Court and file an appeal, or if the High Court does not give you permission, you can directly go to the Supreme Court, and that is called to be able to file an appeal by a special appeal to the Supreme Court. So you file a special leave application to the Supreme Court itself and tell them that we want to file an appeal. Okay. Now see what it says. Appellate jurisdiction means the power to grant special leave to appeal against a judgment delivered by any court in the country. It is a court of appeal. So Supreme Court is a court of appeal, which means that it is a court which may change the decision or reduce the sentence which has been passed by the lower courts. The Supreme Court is a final court of appeal. Okay. The appellate jurisdiction extends to constitutional, civil and criminal cases. So to all types of cases, this appellate jurisdiction is available to the citizen of India. First, we come to the constitutional cases. All matters, irrespective of their nature, where a certificate is issued by a high court that it involves an important point of law and needs interpretation of the constitution, can be brought before the Supreme Court. If the High Court refuses to give a certificate on such a case, the Supreme Court can grant special leave of appeal. I have just explained it to you. Then we come to civil cases. In civil cases also, when can you file an appeal in a civil case to the Supreme Court? In two circumstances. That the case involves a substantial question of law, means the law needs to be interpreted. So there is a substantial question of law, because sometimes the law may have an ambiguous meaning. So if there is a substantial question of law, then you can apply to the Supreme Court even in a civil case. Then the question needs to be decided, and that the question needs to be decided by the Supreme Court. However, if the High Court refuses to give you a certificate, the Supreme Court can grant special leave of appeal in suitable cases. So then you can go to the Supreme Court and take a special leave of appeal. Then we come to criminal cases. In criminal cases, what happens? In criminal cases, there is a particular thing, a facility, not facility you may say, but a particular legal resolve, what would I call it? There is something that there is a particular legal, I'm not getting the right word, availability of a legality by which you can apply to the Supreme Court even if the High Court, and you don't require any certificate from the High Court. Okay, now when does that happen? 1 minute, I'll repeat it again. There are particular cases, criminal cases especially, where the Supreme Court has an original jurisdiction, and this relief is available to the accused. In criminal cases, we have an accused. Okay, so this relief is it's a legal relief which is available to the accused without even asking a certificate or asking the permission from the High Court. When does this happen? When the High Court has picked up a particular case from the lower court and transferred that case to itself, and then the High Court has given a death sentence to the accused, then you can directly apply to the Supreme Court for relief. Similarly, if the High Court has picked up a particular case where a person was acquitted in the lower courts, means he was set free in the lower courts, but the High Court has taken that case, and in that case the High Court has removed that acquittal and has passed a death sentence, then you can directly go to the Supreme Court. Okay, see, two types of appeals in criminal cases lie in the Supreme Court: cases without the certificate of the High Court and cases with the certificate of the High Court. The certificate of the High Court is not required in a case where the High Court has reversed the judgment of acquittal. Okay, so where the judgment was acquitting the accused, given by the lower court, and punished the accused with a death sentence. So if the High Court has punished the accused with a death sentence when actually he was acquitted by the lower court, then you don't require a certificate from the High Court. Also, if a case is withdrawn by the High Court from a subordinate court, so the High Court has picked up that case from the subordinate court and it has given the accused a death sentence, then you can go directly to the Supreme Court. In all other criminal cases, a High Court certification that the case involves a substantial point of law and interpretation of the Constitution is required for appealing to the Supreme Court. So in all other cases, you have to prove that there is a substantial question of law and it requires to be interpreted by the Supreme Court, excepting in the above two cases with respect to the death sentence. Okay. Then we come to the advisory jurisdiction. What do you mean by advisory jurisdiction? An advisory jurisdiction, the very word itself is advice. So what is it? It is giving you an advice. It is not forcing you. It is not a judgment. It is not judging something. It is just giving you an advice. It's like when you ask for an advice from somebody and that person gives you an advice. You are free whether to, supposing you go to your teacher and you ask for an advice from your teacher that how many hours a day I should be studying so that I can score high. Supposing you go and you ask your teacher for this advice. Your teacher gives you an advice. Is that advice binding on you? No, it is not binding on you. It is your choice. You either take the advice or you leave the advice. Your teacher is an expert. She or he has got a lot of experience. Therefore, you have asked for his advice. Whether you take his advice or not, the teacher is not going to force you. Okay, so similarly, there are certain cases which are called as the advisory jurisdiction, where somebody seeks the advice of the Supreme Court, and then the Supreme Court gives its opinion, but that opinion is not binding on that person. We'll see who that person is. The Supreme Court has an advisory jurisdiction to give its opinion on any question of law or fact of public importance as may be referred to it for consideration by the President of India. So when the President of India refers a particular case, a particular question of law to the Supreme Court and seeks its advice, then the Supreme Court will has an advisory jurisdiction. So it will give advice to the President that this is what the law says, this is what should be done, this is what should not be done. It will interpret the law. Okay, and it will give an advice on what has to be done. Okay, now what can you revise? What can you ask? Any question of law may be referred to the Supreme Court if the President considers that question is of public importance and it is necessary to obtain the opinion of the Supreme Court. Such opinion of the Supreme Court is advisory and not binding on the government, nor is it executable as a judgment of the Supreme Court. So it is not a judgment of the Supreme Court, it is just an advice. Any disputes which are arising, so first is on a question of law which the President can ask, and the President may ask and take its advice. That is the first instance of an advisory jurisdiction. What is the second type of advisory jurisdiction? Disputes arising out of the pre-constitution treaties and agreements which are excluded from the original jurisdiction by Article 131. So in the Constitution we have Article 131 which excludes certain matters from the original jurisdiction of the Supreme Court. In such cases, especially in any dispute which arises out of a pre-constitution treaty, means a treaty which was formed before the Constitution came into effect. If there is a dispute in such a treaty, what will happen? So then you can seek the advice of the Supreme Court, so that it gives you its advice. Then we come to the revisory jurisdiction. Now what is the revisory jurisdiction? There is a very thin line between advisory and revisory. Okay, advisory, like I told you, is advising, and revisory means to revise. When I tell you as a teacher, supposing your teacher tells you revise your work and come. Okay, revise what you have learned. What are you doing? You have already done something, but you are revising it. So in a revisory jurisdiction, the Supreme Court has already given a judgment, but the Supreme Court realizes that some error or some mistake has crept into that judgment. In such circumstances, the Supreme Court has got absolute right to revise its judgment, okay, to go through its judgment so as to remove that mistake or error which could have crept in. Okay, the Supreme Court under Article 137 is empowered to review any judgment or order made by it with a view to removing any mistake or error that might have crept in the judgment or order. This is because the Supreme Court is a court of record and its decisions are of evidentiary value and cannot be questioned in any court. Why does the Supreme Court need to do this? Why does it need to revise its judgment? Because it is a court of record. And what do we mean by a court of record? We mean that all the judgments of the Supreme Court, they are recorded and they are preserved as evidence, and we call them as precedents. And these precedents are are given in other courts lower than the Supreme Court, in the High Court and in all the other lower courts and all the tribunals and all. These are cited as examples, or if any other case arises which has similar circumstances and the Supreme Court has already given a judgment on that, then the parties will cite that judgment that there was such a case, there were these particular same conditions which were there at that time also, and this is the judgment of the Supreme Court. When you prove that the case, that the situation of the case is similar to what the Supreme Court has already given a judgment on, then the lower courts will give a similar judgment. Okay, so it is a court of record, and it gives precedence, and its judgments are cited in the other courts, so it must have the power to revise its jurisdiction. Okay, that is a revisory jurisdiction. Now we come to the judicial review. However, so today what have we done? We have done first the original jurisdiction, then we have done the appellate jurisdiction, and I have taught you advisory jurisdiction, and I have taught you revisory jurisdiction. Now we come to judicial review. Now again there is something that you need to understand. A judicial review is different from revisory jurisdiction. What is the difference? Let's see. The Supreme Court is the interpreter of the Constitution, and its decision is final. It has the power to review the laws passed by the union or state legislatures. Now see children, the laws are passed in the legislatures, whether it's a state legislature or whether it is a union legislature. You all are aware of that. So till it becomes a law, once it has become a law, then the Supreme Court has a right to judicially review it. Means because it is an expert in its field, so it can review that law whether it is in the proper spirit and letter of the Constitution, whether it is fulfilling that letter and spirit of the Constitution or whether it is going against it. And who can do this? Only the judiciary can do it. Okay, the Supreme Court can declare a law ultra vires or null and void if it is against the letter and spirit of the Constitution or contravenes any provision of the Constitution. This power is referred to as the power of judicial review, and the minimum number of judges to hear and decide a case involving interpretation of the Constitution will be 5. So it cannot be just one person who decides this matter, whether this law is null and void or not. Minimum has to be 5. If you have more than 5, well and good. Okay, so we call that as an entire bench, and that is what the judicial review means. So I hope I've clarified the meaning of all this. Now I will stop over here and I'll continue in my next module from here, because till then I want you all to learn, to understand and read this entire thing, understand the difference between advisory, revisory and advisory jurisdiction, revisory jurisdiction and judicial review. Why we need this judicial review is what we are going to do in the next module. So till then, here's your history and civics facilitator for the judiciary, wishing you all a goodbye and do study very well. Bye everyone.